Thank you, Mr. Chairman. Judge Casaby, I'm looking at an order you issued as a magistrate judge here requiring the use of pronouns in your court. Do you require the use of pronouns, the declaration of one's pronouns in your court?
Senator, that may be referring to perhaps a trial management order or a scheduling order of some kind?
Yeah. No, it's a statement. You issued it. Here it is.
It's an invitation for people to identify their pronouns and or their honorifics.
Well, I'm looking at your requirement that you issued to all people in your court. You say, quote, when you introduce yourself in a meeting, you should say, my name is Judge Blank and my pronouns are blank.
All right, folks, welcome back to Liberty Trigger. Today, we need to talk about something serious that went down in the Senate hearings. Senator John Kennedy grilled one of Biden's judicial nominees, and let me tell you, it was eye-opening. If you care about fair judges, if you care about free speech, and if you care about the future of this country, you need to stick around. Let's break this down step by step.
Is that right?
Senator, those were not requirements or rules. Those were suggestions and
That was suggestions.
those were suggestions and invitations for people to use.
And you also, in your directive, you say, quote, I'd like counsel to introduce themselves giving your full name and your honorific, such as Ms., MS period, Mix, or Mr., not Mrs., and if your client will be making an appearance, I ask you to please introduce them to the court by giving me their full name and their honorific, such as Ms., MS period, Mix, or Mr. End quote. Is that right?
Senator, it's not a directive. Again, it's an invitation for people to introduce themselves.
Invitation.
Yeah.
Okay. All right. I'm looking at an article from the Oregon State Bar Bulletin from May of 2021. And I want to read one of your quotes. Quote, we have to set aside conventional ideas of proof. Let me say that again. We have to set aside conventional ideas of proof, you said, when we are dealing with the personal and interpersonal work of equity, division, and inclusion. As a judge, I can appreciate the challenge of employing a different mode for understanding truth than that which most lawyers are accustomed to in our work, end quote. Did you write that?
That is a quote from that article.
So when we're dealing with equity, diversity, and inclusion, we should set aside conventional ideas of proof. Is that right?
In the larger context of interpersonal and personal relationships, the idea of being able to have a conversation with somebody.
Yeah, but you didn't talk about a conversation. You said proof.
It's in the context of having a conversation with somebody about the issue of their background and their experience.
So when the issue is equity, diversity, or inclusion, we should have a different set of proof. Is that right?
When it comes to the space in which people have interpersonal relationships with one another, the idea of respecting and dignifying each other with their experiences is an important part of...
So all issues have one set of proof, which has been handed down by our state Supreme Courts, our U.S. Supreme Court, except you think we ought to have a different set of proof when equity, diversity, and inclusion are at issue. Is that right?
In all of my years on the bench, Senator, I have applied the law, the rules of evidence, the case precedent.
Let me move on. I'm looking at the notes you gave us from a speech you made in February 7, 2020. It's entitled Speech Reflections on Equity and Privilege to the Oregon Blacks in Government. You wrote, quote, white, male, straight people allow privilege to remain in place, close quote. Did you say that? Did you write that?
Without looking at the specific
Here it
speech
is. You turned it in.
Well, if that's in If that's on the piece of paper, Senator, then I have no
Okay.
reason to disagree.
You also wrote, quote, privilege is incredibly similar to narcissistic personality disorder, close quote. Did you write that?
Without looking at everything in the context of that statement, it appears correct.
Okay. You wrote, quote, the identity of Muslims also need to be normalized in a country that is so deeply Islamophobic. Did you write that?
Senator, I did. And what I'd also like to clarify is that in the context of my work on the bench, I have treated everybody equally without regard to their
I'm sorry, I
background.
just want to get through this. I'm going to run out of time. You also wrote, quote, I am disappointed about the way in which the founding fathers of this country perpetuated inequity, close quote. Did you write that?
In the context of the issue of slavery, that was something that I'd been considering.
In your notes you gave us from a speech on May 17, 2023, does race matter? You said, quote, does race matter? Hell yes, close quote. You know that T-shirt at the Saturday markets, the one that says something like love, see no color, and it has all the colors of the rainbow all over it, and it's like a tie-dye shirt. Well, the first time I saw it, I said, ah, how sweet. Then I got angry. If love doesn't see color, then I don't have allies, close quote. Did you say that?
Yes, and that was to explain that the work of equity is to help understand where people are coming from, not to ignore who they are.
And you also, yeah, no, I'm sorry. Can I have 30 more seconds? Judge, you seem to be obsessed with race and sexuality. I mean, you even go so far as to say that when race and sexuality and diversity and inclusion are at issue, we need a separate standard of proof in the United States federal judiciary. How are litigants going to be able to trust you?
Senator, that's not what I've said. There is
Sure
no
it is.
different
Here it
standard.
is, bigger than Dallas. I read it to you.
When you look
turned
at-
in these documents. I didn't go looking for them.
When
You
you look
seem
at,
proud of it.
as anyone who reviews my record on the bench,
I
for
have.
thousands of cases.
I'm going to let you finish responding, and your time has expired, but go ahead.
The rule of law is an absolute for me. The work that I have done on the bench over
That's
the last
not what you
16
say.
the work that I've done on the
But
bench
that's
for-
not what you say.
Judge, finish your sentence.
the work that I've done on the bench in ruling over all the people's cases that have appeared in front of me from all backgrounds, of all faiths, you'll find that I have upheld the rule of law and upheld the precedent of our Constitution and our Supreme Court and the Ninth Circuit.
Well, if this chairman would give me time, I could go through the cases and prove that that's not the case.
Senator,
I just don't see how you can be a fair-minded judge.
Senator Booker.
So first, Senator Kennedy asks this nominee if he ever described himself as a wild-eyed sort of leftist. And what does the nominee say? He tries to walk it back, says it was a caricature. Folks, this is classic. They say something radical to their buddies, to the Twitter mob, to the activists, but when they're under oath, suddenly it was all a joke or a caricature. Give me a break. Next, Kennedy presses him about calling republicanism an anti-democratic virus. And what do we get? Denial, denial, denial. I don't believe I said that, he repeats over and over. But here's the kicker. He admits he did say that election distrust spread like a virus. Now, come on. Do we really believe this guy never crossed a line into slamming Republicans as a whole? The left does this all the time. Demonize conservatives, then play innocent when they're caught. Kennedy asked the million-dollar question. If you actually said that, would you withdraw your nomination? And the nominee couldn't give a straight answer. He danced around it. Folks, if you can't stand by your words, maybe you shouldn't be a judge. Federal judges need to be people of integrity, not political activists hiding behind technicalities. Then we get to the tweets. Oh boy, this nominee went after Senators Cotton, Blackburn, and Cornyn on social media. And what's his defense? I regret the tone. Not the words. Not the message. Just the tone. You see what's happening? He's sorry he got caught. He's not sorry for being partisan, angry, and reckless. He says Twitter is a coarse place, and he contributed to the coarseness. You notice how that's always the excuse? Oh, I was just being edgy on Twitter. Everybody does it. Well, here's the problem. This isn't a teenager arguing online. This is a man who wants a lifetime seat on the federal bench. If you can't control yourself on Twitter, how are we supposed to trust you with the Constitution? Kennedy nailed him. Do you regret it because you didn't mean it, or do you regret it because you might not get confirmed? And what does the nominee say? He dodges again. Folks, this is exactly what we're tired of. Politicians and judges who regret things only when it hurts their careers. That's not regret. That's self-preservation. Then there's this moment where the nominee tries to cloak himself in religion and morality, equal dignity and worth. Sounds nice, right? But let's be honest. If he truly believed in dignity for everyone, he wouldn't have trashed conservative senators online. He wouldn't have dismissed Republican voters as some kind of virus. Words matter, and his words tell us who he really is. Senator Kennedy looked him straight in the eye and said it. You're a smart man, but you're an angry man. And we don't need angry federal judges. Folks, that's it right there. Judges shouldn't be activists. They shouldn't be hotheads. They should be fair, balanced, calm, and rooted in the law, not in Twitter fights and partisan bitterness. Now, some people might say, oh, come on, everyone tweets. Everyone says dumb things. Sure, but not everyone is asking for a lifetime seat with the power to shape our laws and freedoms. If this guy can't handle Twitter without insulting Republicans, imagine what he'll do when conservatives come before his courtroom. Listen, this is a problem with so many of Biden's judicial picks. They're chosen not because they're impartial, but because they're activists, because they'll push the agenda. And they'll smile, they'll dodge, they'll deny when they're under oath. But their record speaks louder than their excuses. Senator Kennedy was right. We don't need angry judges. We need judges who love the Constitution more than they love Twitter likes. We need judges who see Americans as equals, not as enemies. And until we start demanding higher standards, this circus is going to continue. All right, folks, that's my take. If you agree that we need fair judges, not angry activists in robes, hit that like button, share this video, and make sure you subscribe. The fight for America's future is happening in the courts just as much as in Congress, and we can't afford to sit this one out. God bless you, God bless America, and I'll see you in the next video.